So I've got next in the program notes at don'tletitgo.com a link to Center for the Legalization of Privacy. And those of you who either haven't been following me that closely or not that long don't really know about this, but this has been kind of on the back burner for me for a long time. And then it came to the forefront this last year in 2019. I decided I'm going to go ahead and make this an actual legal entity, an official legal entity, the Center for the Legalization of Privacy. I've been, I had legalizeprivacy.org for a long time, but finally made it an official entity, and in part so that we could file an amicus brief in United States versus Facebook. And United States versus Facebook is the FTC going after Facebook for supposed violations of user privacy. That's what it's about. And what I have to offer that is unique in this sort of case is a theory that I think is helpful in addition to a trend that's already been happening in the law, okay? And there's a trend that already was kind of started with the Snowden revelations in 2013, but then in terms of Supreme Court precedent was showing some sort of effect in 2018. And it's this, okay? In the law, ever since the 1970s, this is what has been the case. They have said that if you share information with what is called a third party, so if you share information with Facebook, if you share information with YouTube that we're on now, if you share information with Twitter, if you share information with your bank, if you share information with your cell phone provider, if you share information with anybody, then the law has been saying that the government can obtain that information from Facebook, the bank, whoever, without a warrant. That means there's no probable cause, no particularized suspicion about you being guilty of any crime. Nonetheless, the government can grab it. The only thing that can protect your information in that context, because there's no Fourth Amendment protection according to this precedent that's been there for decades, the only thing that can protect you is a statute. So for instance, in email, they've had something called the Stored Communications Act. And email, and then Facebook is arguing that it also applies to communications on Facebook as well. But the Stored Communications Act will say that if there are communications that have been stored for less than a certain period of time, less than 180 days, then yes, they still would have to maybe get a warrant. But if it's been stored for more than 180 days, then they could get it with just a subpoena, right? And so you don't have to have probable cause or particular suspicion. Now, what is this though? This is a statute, and it applies only to the content of communications. So even that protection that you get with respect to your communications applies only to the content of the communications itself. It doesn't apply to what you've heard in the news called metadata. And that could be just the
who
length.
I spoke to when, how many times
who you spoke to when,
yeah,
how many times, for how long you spoke to them, or how many characters were in the text message, or whatever it was, right?
Right.
So there's a lot of personal information that some statute like that doesn't cover. And then you're left to the mercy of whatever judge is sitting in the court that day, right?
Right.
Okay, so this has been the case for decades. Now then you say, okay, so Amy, what is it that you have to say about this? It happens to be the case that back in 2012, I thought of the solution to this problem. I thought, I identified where I believe the Supreme Court went wrong in the 1970s, putting us in this direction. Because in the 1970s, with respect to a phone company and your bank,
this broad third-party doctrine.
The third-party doctrine is what it's called. And that's when the Supreme Court said, if you share information with the phone company or with the bank, the government can obtain it without a warrant. And that's when we started down this path. So that's what I uniquely have to offer, is a theory about this. It's a theory that's rooted in the common law. I'm not going to go into it in detail now if people are interested, but my point is that I have a common law-based solution to this problem. In 2018, the Supreme Court itself showed that there are at least limits to the application of this third-party doctrine. In 2018, there's a case called United States versus Carpenter, actually Carpenter versus United States. It gets switched, which party is the lead party in the case title. But in any event, they said in that case that the communication, the location data with your cell phone provider, right? Cell phone provider is always getting some communication data about you, but your cell phone provider also collects location data. So
my phone knows where I am at every time.
Exactly.
Just plug in and it says, do you want to let people know that you're here? It'll tell me because we know you're here.
Right. We know you're here. And do you want to let people know? Right. And so at least the Supreme Court said that with respect to 127 days worth of this location data, that the government would have to obtain a warrant in order to get it. So they said, okay, there's some limits. And what my concern is with the United States versus Facebook case is that under the guise of protecting us, that's what the FTC thinks that they're doing. They're protecting us from big bad Facebook and all their privacy practices. I don't take a position on that. And CLP does not take a position on that in the amicus brief at all. All we say is that whatever you say about Facebook, we should not, as part of the enforcement, give government warrantless access to Facebook user data. And the settlement order that is before the court appears to do that. And so what I did in the brief that I wrote in October is show the parts of the settlement order that appear to give this warrantless access.
Right.
I argue that based on both the precedent in Carpenter and, of course, where I think it should go, this trend towards limiting the doctrine should go, which is to scale it back to pre-1970s scope, both of those show that the government is not entitled to rely on the third-party doctrine in order to give itself warrantless access to Facebook user data,
right?
Pretending that they're protecting our privacy.
Right.
That's what I argued in October in the brief. And so, I had to start up the organization and do this and hire a local counsel so that I could file it in the DC circuit. And that's what I did. Even though I was sick and everything, I didn't feel good enough to be on air, but I could sit there and type a brief, in front of a computer. Right. So I did that.
And you were able to appear and give testimony on it.
No, not there.
Not there, but you were still able to talk about it.
Well, right. But where I then appeared was very recently. So very recently, I've been feeling quite a bit better.
Yeah.
And I took the step that I was a little nervous about, but it worked out fine, was traveling, which I hadn't traveled all this time since I've been sick either. Traveled to New Hampshire, even longer flights and everything. So
I went to New Hampshire is considering legislation on this?
Yeah. So New Hampshire is considering amending their constitution in accordance with what I think is, again, the right solution to this third-party doctrine problem. And the solution, again, has to do with scaling back the doctrine to its pre-1970 scope. And in essence, what it does is it says, if we are not criminals, if we are just ordinary people sharing information with phone company, bank, anybody else, Facebook now, all the modern ways that we do it. One example I love to use is the grocery store. They have their little discount membership club and you're sharing information about your habits with them, et cetera. All this information that we share all the time without even thinking about it, we're just law-abiding citizens. And the contracts that we make with these service providers are perfectly legal contracts. And I'm saying those should be enforced because
shouldn't contract govern this matter? I mean, if I want special privacy, I can negotiate for it. If I don't, if I want to allow the person that I'm giving the information to use it and share it, say with advertisement and marketing people, that should be a subject for the provider and the person to negotiate privately, contractually. If I want to, such as when I go to a doctor, I expect privacy from the doctor, or a lawyer, I expect, or with my wife, I have a certain amount of. Can't I contract for a specially private relationship?
Yes, and that's what we should be able to do. So when I talk about Center for the Legalization of Privacy, I actually say we need to legalize privacy, and that today privacy is essentially illegal because according to this precedent set in place in the 1970s, we have not been able to make a legal contract with service providers that includes provisions that protect our privacy vis-a-vis government. Suddenly, they're entitled to warrantless access to everything just because we are out there getting services, goods and services that enhance our lives. That seems very wrong. And as I said, there is a solution in the common law for this, and I've detailed it a number of times. Go to legalizeprivacy.org. Also, the most recent way that I did detail it, Jim was talking about that. I had the privilege of speaking before the New Hampshire House Judiciary Committee and in favor of this proposed constitutional amendment, explaining exactly how it is that the common law supports allowing people to make legally enforceable contracts that include provisions to protect their private information, and that these contracts should be treated as anything else, person, houses, papers, effects, in the Fourth Amendment.
Right.
We need to do
this. If it all turns on, and I've never been very comfortable with this as a standard, but if it all turns on a person's reasonable expectations of privacy,
yes,
as the Supreme Court has said repeatedly, it seems to me that those expectations should govern. That is to say, if I put something into my home or into a safe, or if I say to my lawyer, keep this quiet, the privacy is what I control and what I expect, right?
Right.
Isn't there any way for the person, the individual, to demand increased privacy for something? There really ought to be, right?
Well, and this is the problem with the whole reasonable expectation of privacy standard, because reasonable means that society is prepared to recognize it as reasonable. And one of the familiar
argument,
right? And in the 1970s, when Smith and Miller, they're two different cases. So there's Smith versus Maryland and Miller versus United States, the phone and the banking cases respectively, right? Those cases just involved phone numbers that you dial, some metadata with respect to Smith, and with respect to Miller, certain transactions that were governed by regulation. The government sweeping up all this information about our financial transactions with their regulatory schemes. And, that's about the most personal data maybe that we had in the 70s. And, the cases involved these horrible criminals. And so nobody really cared. And it's only now that we realize how ubiquitous, how just commonplace in our lives sharing information is. There's so many services, goods and services that are available to us that enhance our lives, that depend on us sharing information. We'll take YouTube, for example. We're right here on YouTube. YouTube, by the way, give us better placement for this, for this video, because of what I'm about to say in favor of YouTube, right? So seriously, come on, YouTube, help us out here. Help us out here. Give us better placement for this video. YouTube will, when you go there, suggest the most awesome music videos based on your past watching history. And this is something that can enhance your life.
Spotify, Amazon, they all do it, right?
Yeah, and so they enhance your life, but that depends on sharing information with them. It's just one tiny example, but yeah, if you think about it, go through your daily life, all the ways that you share information and they make your life better accordingly, then why is it that somehow availing yourself of these advances, these improvements in our lives is, getting you treated like a criminal by the government, where they get warrantless access? And when I say treated like a criminal, again, my common law solution to this problem has something to do with that. Basically, they are treating us all like criminals. If you want more details, go to legalizeprivacy.org, watch the YouTube video that I've got linked to in the program notes at don'tletitgo.com. It is my testimony to the New Hampshire House Judiciary Committee, where I explain the wording of the proposed constitutional amendment, its roots in the common law, and how it's going to prevent us all from being treated as criminals were pre-1970. That's where the Supreme Court went wrong.
It's just crazy. I have a conversation with someone, a private conversation with someone in my home or in my car or at a table at Starbucks. That's treated in one way. If I have a conversation over my telephone or with Facebook Messenger, that's treated another way. That doesn't make any sense whatever to me.
Actually, it's all treated the same way as long as your cell phone on you. You know this.
Right.
No, I'm serious. You will be having a conversation. Seriously. I had this happen, I believe, just yesterday. You'll have a conversation, but your phone is near you. And, I do iPhone. And I don't know if this is stored anywhere, but I do know this, and it's a little unsettling, that if you then go into the Safari browser on your iPhone and you start to Google something related to your conversation, the exact thing that you are looking for based on your conversation will show up after you type maybe a few characters only, and not enough distinguishing characters to have given you that result apart from Siri listening to your conversation. And it showed up yesterday as a Siri suggested result.
Wow. Oh, wow.
So
wow. No,
it helped me. It helped me tremendously, but I was sharing with a third party.
Right. No, Holly and I have noticed some creepy things that way. We'll be looking for something, and then suddenly we'll get a whole slew of advertisements for related things.
Oh, yes.
Someone's paying attention to everything we do on our phone. That's for sure.
Yes. Now, I believe that Apple, I believe that Apple is still holding firm on the fact that our phone is encrypted. And so if that is kept in my phone and it's just something that is a cool feature of my phone, subject to Apple encryption, I'm perfectly happy with that. But that's one of the things that I would like to do with the Center for Legalization of Privacy in the appropriate way. I haven't figured out what the appropriate way is yet, but there's a lot of buzz. There's a lot of buzz about politicians wanting to ban encryption, to mandate a backdoor to our phones. This is just one of the projects that I would like to do. But as I said, I've got two projects right now that have heated up in the last few months I've been busy with. One is the United States versus Facebook. And the cool thing in that case is, think about this, and this is pretty rare. I file an amicus brief, a friend of the court brief. I'm not a party to this case, and I'm one of 3 amicus briefs that have been filed there, right? And the judge took the unusual step of ordering both the parties, that's the government and Facebook, to respond to all the arguments in all the amicus briefs, which meant they had to confront and respond to mine, which was unique. The CLP brief was the only brief to raise Fourth Amendment concerns from the FTC Facebook settlement order. So I am really proud of the fact that I'm really, because I raised the concern. I said it's a concern even in light of the existing precedent from Carpenter. Even Carpenter calls into question whether Facebook data is similar enough to 127 days worth of cell phone location data in Carpenter. You know how the legal arguments go, right, Jim? You have to make an analogy. But I made the analogy that said even under the existing precedent, but if you read the writing on the wall and you see the way that this is going, for instance, Utah has eliminated the third-party doctrine entirely by statute. I think it's a mistake. It goes too far. And in my New Hampshire testimony, I explain why you shouldn't eliminate it across the board. What you should do is you should revert it to the old scope. In a very principled, bright line fashion, made possible by the common law. It's there. The answer is there.
And be governed by contract.
But this is the direction it's going. People are saying this third-party doctrine, there's something wrong. We shouldn't all be treated like criminals. And
now, of course, if they have probable cause that a crime has been committed, that evidence of a crime is there, then they can get a warrant. And moreover, if they put secret agents into criminal conspiracy situations, they'll still be able to do that. That's what Utah's not going to be allowing under their law. They made a mistake, I think, So my solution preserves government's ability to use secret agents in infiltrating criminal schemes, while at the same time making sure that all of us who aren't the Tony Sopranos of the world are not treated like criminals. And that's what I think I uniquely have to offer. That's what I deployed in Facebook. And that's what, has now made both Facebook and United States confront Fourth Amendment arguments. And you can see what their responses are. Again, if you go to legalizeprivacy.org, you can see what Facebook's attorneys and what the government attorneys wrote in response to the Fourth Amendment challenges that I raised
with respect to this settlement order. Of course, they say I'm crazy, but you see what they say in terms of, especially what the government says, in terms of their entitlement to our data.
Yeah.
And it might disturb you. So go to legalizeprivacy.org. If you are interested in supporting my work, please do. 99% of what I have done so far in the past several months is funded only out of my non-deep pockets. And I did it because in the Facebook, I had to do it. I actually think that government obtaining our Facebook data under the guise of protecting us is the next step towards 1984. We don't want the social credit system in here, the China social credit system. So, I had to send this out there. I didn't know what it was going to do. The fact that the judge even ordered them to respond
well done.
was amazing. So you expose this, right? So if anybody's listening, if anybody cares, go to legalizeprivacy.org and please consider sponsoring. In the program notes, I put 3 ways that you can support my work. Not everybody who would be interested in making a larger donation would want to go through those channels. And if you want to talk to me about what work that I do might be 501c3 tax deductible and you want to make a larger donation, I'm thinking of doing a hybrid, like a 501c4, where some of it is tax deductible and some of it isn't. Because if you are, for instance, arguing in favor of specific legislation, like I was in New Hampshire, which I think is something that I want to and should try to do, that wouldn't be tax deductible. But for instance, if you do things in litigation, like Institute for Justice and other wonderful organizations do, then it is 501c3. It's allowed to be tax
Interesting
deductible.
The way the tax code is.
Yeah.
Right?
And so, I think that there is good work that I can do in deploying this solution in both realms. I think both are important. Again, I'm working within the law. I'm not some anarchist, as you'll see if you go look at all of my things. I'm interested in still preserving proper role for law enforcement. But I want to get government not treating us like criminals. I want to avoid Orwell's 1984 from becoming reality. And I think I can do it in these 2 realms. If you'd like to help me, legalizeprivacy.org.